proportionality is the only other thing I'm going to deal with in relation to Dalston. And on principle, in relation to proportionality, there's no separate real issue of principle in relation to Dalston. We're dealing with a power in that context conferred by Parliament to detain vessels on the basis of connection to Russia, as we saw. And a recognition is needed of the purpose, which is to enable the sanctions that undermine support for and seek to influence the Russian state. But that's essentially the same purpose as we saw in Shvidler. And I made the point earlier that the breadth of the connection test in that criterion needs to be seen alongside the fact that it applies only to a specific type of asset, which is ships and here a super yacht. But all the other points I made in relation to Shvidler apply equally, including the significance accepted by Sir Ross Cranston of margin. Legitimate aim in relation to Dalston, again, the appellants in that case have accepted that there is a legitimate aim here. I gave you the reference earlier on, but I give it here just in case. Driver 1, 9 to 13 and 135, effectively explaining why there could hardly be a more important set of objectives than the one here, and explaining why the detention of assets such as the fee is a part of the government's foreign policy response to the war in Ukraine, and part of a much wider package of measures, including diplomatic, that are designed to affect and persuade Russia to try and cease the actions that they're engaged in Ukraine. So legitimate aim, common ground, engaged, same point as I made under the Shvidler appeal, could hardly be more important, and that feeds into all the bits that then follow. Rational connection, again, a very significant body of evidence before the judge regarding rational connection. The relevant evidential reference for that is driver 1, paragraphs 136 to 139, and our skeleton in this appeal at paragraph 32.1 gives the court all of the cross-references, should you need them, to those points, both in the driver evidence and in the contemporaneous ministerial submissions. Essentially 6 reasons identified. Firstly, Mr. Naumenku was connected with Russia and thereby satisfied the regulatory criteria, and that is important to the statutory power to detain because it's evident that Parliament deliberately broadened the ways in which sanctions might be applied as the legislative regime developed in order to rank up the pressure on Russia, and the fact therefore that you fall within the test that Parliament has designed in that way is a matter of real significance. Mr. Naumenko, as you have already seen, was an individual of very significant wealth, as is clear from, for example, driver 2, paragraphs 9 to 13. Thirdly, such significant wealth indicated a high level of economic activity which, combined with Russian residency, was likely to benefit the Russian regime. But you will have seen from the evidential references I gave you earlier that generation of wealth was in pretty significant part, and even on his own second-hand evidence, as it were, derived from work for the Russian regime, the building of houses and offices that is referred to in the evidence, and from the sale of one of his businesses to the state-owned Russian bank, which is now itself sanctioned. So there's that, as it were, direct connection between the very, very significant wealth and the Russian regime. And that sounds into the 4th point, which is stuff of the Respondent's notice, but it perhaps matters not, which is that there was plenty of evidence before the court about Russia's political economy and the use of patronage, which pretty much went to the same end, which is that if you're going to, the point in very brief summary form being that if you're going to engage in the generation of wealth on that scale in Russia, the expectation of the Russian regime is that you will conform, and so there is that degree of connection implicit in that patronage point in any event. Fifthly, the implementation of sanctions against what might be thought to be the totemic vessel, which is the fee, a super yacht of that worth, has a wider and important signalling function beyond Mr. Naumenko, but also to him, and indicates to others the need to disassociate and therefore divorce themselves from any form of support for Russians' activities. And then sixthly, limiting the ability of high net worth individuals of this kind to enjoy that sort of luxurious lifestyle is itself properly to be perceived as a tool which applies pressure on the Russian elite, the Russian economic elite, if you will, with the same broader aim and intention. All of that was considered with conspicuous care by Sir Ross Cranston. See in particular paragraphs 83 to 84. I've dealt already with 85 to 86, which was the principal ground of criticism in relation to rational connection, which is the point about viewing the rational connection in its cumulative sense, and not simply isolating a single strand, and certainly not demanding some form of empirical evidence that indicates that each and every one of the strands, or any of them, could themselves influence Putin to withdraw from Ukraine. That is not the game that is required to be played under the legislation. And we respectfully submit, for all the reasons I gave earlier, when I picked up the corresponding reference that Mr. Justice Garnham had dragged back into his judgment, what was in fact being said there, it was simply a point about not requiring that sort of empirical evidence for individual strands, and the need to stand back and look comprehensively and cumulatively when assessing and judging rational connection. So that's rational connection. Fair balance, that is addressed in the evidence.
Sorry, are you going to address less intrusive measures?
My lord, I wasn't planning to. I'm sure.
No, I just wondered if.
I wasn't planning to specifically, unless you.
No, that's fine.
Yeah.
Just wanted to make sure you covered that.
I mean, the point on, I suppose, on less intrusive measures is that it was detection of a single boat. So you either do that or you don't. Which is why I perhaps feature so highly. But apologies, yeah, that is obviously the third stage. But fair balance, the evidential references for your note are in Driver 1, paragraphs 143 to 150, supplemental bundle pages 80 to 82. It was dealt with by the judge at paragraphs 87 to 88 of his judgment, and it's evident from those paragraphs that the judge had regard to the significant harm caused by the fee's detention, but he balanced that against what he described as the weighty public interest factors in the UK's foreign policy response, which seeks to have as broad and deep an impact as possible, and that, I respectfully submit, if it is controversial, is an entirely fair description of what the legislative regime and its basic purpose, including the 20 amendments, as it were, all of which are to the same end, i.e. broadening it out. It's a perfectly fair description of what indeed Parliament has decided should be done. And my respectful submission is that that approach and that conclusion on that side of the balance properly chimes with the decision and reasoning of Mr. Justice Garnham at paragraph 138 of his judgment. I add one footnote as the final point in my submissions, and one footnote only on proportionality. In contrast, it might be thought, to the very significant body of evidence filed on behalf of the Secretary of State in this case, Mr. Naumenko has elected not to file a statement from himself, which seeks to identify and deal with any of the matters identified by the respondent. So there is no witness statement denying that he's benefited, for example, from the system of patronage in Russia. There's no witness statement setting out his position on the war in Ukraine. The most we have is a letter at 233 to 234 of the supplemental bundle, and some translated hearsay in the witness statement of Sir Ian Collett at page 95 of that same bundle. But that material simply doesn't grapple with any of those things. Of course, that isn't dispositive. It's his right not to put in evidence if he doesn't want to, but it is striking that we have nothing by way of direct evidence from the second appellant in this case. My lord, my lady, those were my submissions. That leaves you with grounds 2 to 6 in the Dalston appeal, which are going to be picked up, as I indicated earlier, unless I can seek to assist further.
Thank you, Sir James. Mr. Pobdry. My lords, my lady, the plan is that I will speak for about 30 minutes, and then Ms. Plews will stand up with the aim that we'll both complete by 3 o'clock. And I'm very optimistic.
Don't feel rushed.
That we will achieve that. I'm dealing with grounds 2, 3, 4, and 5. Ground 2, improper purpose. The appellants are alleging that this is an example of a statutory power being used for a motive or reason outside the purposes for which the power has been conferred. Of course, under Padfield, in exercising discretion, the Secretary of State has to act consistently with the purpose of the legislative scheme. That is not in dispute. We say that is precisely what has occurred here, and the judge was right to reject this ground, and he did so at judgment paragraph 63 to 69. 5 short points in response to this ground, in particular the way it has been advanced orally. Point 1, a statutory power to detain existed, and that power to detain must necessarily fall within the regulation for purposes. Otherwise, it wouldn't be varies. And there's no suggestion in these proceedings that it is ultra varies. That's point 1. Point 2, the criteria in regulations 57C and 57D for the movement and detention directions are satisfied in this case. And that is because Mr. Nemenko is the ultimate beneficial owner of the fee, something that's not in dispute. And we say that satisfaction of the statutory criteria is a very strong indication that the Secretary of State has acted consistently with the purposes of the legislation. Point 3, the contemporaneous evidence provides a clear and detailed explanation as to the purposes of the designation, which are, we say, entirely consistent with Regulation 4. And although our position is that satisfaction of the criteria themselves provides a very strong steer that the detention satisfies the statutory purposes, the court also has the benefit of that contemporaneous evidence and also, of course, the witness statement of Mr. Driver. I'm not going to go back through any of that material. I do just want to show you one thing, which is the appellant's skeleton argument at paragraph 48, which is in the core bundle, page 43. It's tab sorry, 1 second. Page 43, tab 4. Paragraph 48. This is under the head of ground 2, Padfield. And my learned friend, in his written submission, says in terms, of course, and subject to arguments about rational connection, the respondent was acting for the general purpose set out in Regulation 4 in taking the actions that he did. So, again, we are struggling somewhat to see how the detention decision did not fall within the Reg 4 purpose. My 4th point, and this is where the argument really seemed to go during the course of submissions, is that it's actually a debate about the scope of regulations 57C and 57D, and the attempt to introduce some sort of implicit limitation into those provisions to say that it's not any ship, even though that's what it says. It's just ships conducting trade or doing specific things. Now, Sir James dealt with that in some detail, and I really can't improve on what he said. I just want to give you two additional references that further support that point. And you don't need to turn either of them up, but the first is the appellant's skeleton at 54.2. That's CB tab 4, page 46. And that's where they accept in terms that if it's the first limb, so if you're a designated person, then it doesn't matter what the ship is. It doesn't matter what the ship is doing. If it's a yacht, that's absolutely fine. But that the limitation only gets read in to the second provision. And we say that incongruity is just an impossible reading of the legislation. And the second reference I wanted to give you, just in relation to this construction argument, is the Section 46 report. And just to remind the court, at the time that the amending regulations were made, so the amending regulations that introduced 57A to 57D, there was a requirement under SAMLA that there be what's called a Section 46 report, which explained how those amendments furthered the regulation for purpose, effectively. And so that's what the Section 46 report was doing. And that report is authorities, and you don't need to turn it up, it's authorities tab 55, 2269. And my learned friend relied on it because it had the words about disrupting shipping. And just two very short points on that. Well, it doesn't say disrupting the shipping sector or disrupting trade, it's just disrupting Russian shipping. And we say holding an iconic vessel like that is doing precisely that. If you then go on, and it's paragraph 8, subparagraph C, you can see it further particularises precisely how government is intending to do that. And it says, in terms, that it is adding a power to detain, and I quote, any ship. So we say, you don't need to go to that sort of, that material because the legislation is entirely unambiguous. But if you did, that further supports the Secretary of State's interpretation. The fifth and final point under this ground is just to make the point, the fact that Mr. Nemenko has not been designated is entirely irrelevant. And I make that point because that was a real focus of the submissions in the High Court below, and also in the written submissions here, because the argument that's being run is, in effect, that the Secretary of State is trying to use Regulation 57C and 57D to circumvent the designation powers. And we say that it's very clear that these are distinct regimes. It couldn't be clearer from the face of the legislation. And so it is irrelevant that Mr. Nemenko is not designated. So we say judgment paragraph 62 onwards are correct for the reasons given there. So that's ground 2, unless there are any further questions. And I was proposing going to ground 3, which deals with the stated grounds for detention. And so the argument here is that what was said in the decision, and my learned friend fairly took you to it, it's not the letter, it's actually the kind of the formal direction, and that's at Call Bundle, tab 18, page 235, did not satisfy the requirements under Regulation 57D5C to state the grounds. We say that's precisely what the Secretary of State did. Regulation 57D 5 sub C does not require a statement of reasons. Contrast regulation 8 subparagraph 4 in the same regulations. That's what the judge said at paragraph 56 of the judgment, and we say the judge was right. Now, my learned friend's submission orally was that the requirement is to set out the grounds on which the ship is detained, not the basis upon which the ship can be detained. I.e., you can't just set out the power. But if you have a look at 235, that's not what has happened at all. We very clearly, the Secretary of State has very clearly identified that the ship is detained because Mr. Nemenko, who is named, the individual is named, is connected to Russia. Doesn't set out the full provision saying connected to or a designated person. It makes it very clear the statutory ground, the specific statutory ground that is being relied upon, and the fact that it is because Mr. Nemenko is the owner. So it's just simply not right that it sets out the grounds on which it can be detained. It's very clearly set out the grounds on which it was detained. It's also not clear to us, with respect, where the point goes. Insofar as it's being suggested that there are insufficient reasons to allow a challenge to be mounted, well, that's not accepted. Or in this case, all of the ministerial submissions were provided at the pre-action stage, and so there was no impediment on the appellants initiating these proceedings. There was a specific complaint about the judge not referring to the South Gloucestershire case. That is in fairness to the judge below, because of the way things developed orally, and this argument was not seriously advanced orally, and the judge records that at paragraph 55 of the judgment. But in any event, that authority relates to an entirely separate scheme, entirely different factual context. It was a quasi-judicial context where effectively you make an application to the council, you put in representation as an appeal about which school your child is going to. Representations are made and there's a decision by the council. And the statutory requirement is to render a decision which sets out the grounds upon which that decision is based. That's the statutory requirement. That's authorities tab 9224. That's an entirely different situation to the present context. So the judge was right not to place any reliance on it. Just a final point under ground 3, insofar as it's necessary. If this court was to disagree with Sir Ross Cranston and find that there has been some form of procedural defect, that would still not render the detention invalid. And we rely, for that proposition, on the Van Gogh case, paragraphs 30 to 33. That's authorities, tab 21, page 953. Ground 4, the reasons for the initial march.
I'm sorry, I don't understand that last
Yes.
point. Why, according to conventional public law principle, doesn't a breach of a statutory requirement mean that the resulting decision is invalid?
Yes, it may help, and perhaps I'm going too speedily if I actually take up the Van Gogh case, because I can explain it from that. So it's authorities tab 21, page 953. And it came down to a question of statutory construction. And I take the point, of course, that it is a different statute, but we say very similar reasons apply here. And if I can just invite the court to read through the sideline passages, para 30 to 33. it's effectively kind of a form over substance point, and whether or not Parliament could have intended that a defect in the notice would render an otherwise valid notice invalid. So that's the point. I totally accept that if there was some form of procedural unfairness because they weren't able to come to court with full sets of reasons or something, that could be a distinct procedural fairness point, but we say not invalid. So ground 4, the reasons for the initial March decision. My learned friend relies on a number of comments made by the Secretary of State at the time of the detention of the ship, in particular references to oligarch and references to being connected to Putin. And the judge made a finding of fact that those media comments were in effect political messaging.
So
Political messaging. And that's paragraph 69 and paragraphs 90. And he also referred to the fact that oligarch had a common meaning of a very wealthy Russian. And that's 69.
It wasn't really about political messaging. It was about that you read back from what he actually said to his reasons.
That's certainly my learned friend's argument, yes. And so I have 3 points in response to that, and in those 3 points I can assure the Master of the Rolls I'll respond to his query. So the first point, and we say this is the most significant, is that you have Mr. Driver's evidence, and which sets out in detail the reasons for the initial March decision. There was no cross-examination of Mr. Driver. At paragraph 91, that supplementary bundle, tab 3, page 62, he says, in terms of the first and second decisions were not taken for any reasons other than those that were set out in writing in the 8th of April submission. And I just want to emphasise the importance of the 8th of April submission. So that was just a few days after the decision, and I will take that up at supplementary bundle, tab 32, 213. This is the submission. The relevant, if we can go over to 218, which is what sets out the rationale. And at paragraph 3, in deciding to detain the ship, the Secretary of State commented that it was most certainly both in the public interest, and then it goes on, it was felt that, etc. Now that's very clearly in the past tense, explaining the basis upon which the initial decision just a few days earlier was taken. This is a submission that went to the Secretary of State, that was then presumably agreed by the Secretary of State, or we know that he accepted the recommendation in it, and we say that provides the clearest contemporaneous record of the basis of both the April decision, but also the first decision, because it's setting out just a few days later why that first decision was taken.
I'm afraid I'm having difficulty.
Yes, of
following
course.
This.
Yes.
First of all, the decision was taken by the Secretary of State personally.
Yes.
He hasn't filed any evidence as to what was in his mind, nor I think, but correct me if I'm wrong, does Mr. Driver say, I've spoken to Mr. Shabs and he's told me what his reasons were.
No, that's right.
The second point is that although you keep saying that this is a few days after the relevant decision,
Yes.
it's still some time after that decision, and the point that's made against you is that if you want to know what was in the Secretary of State's mind when he personally took the decision, the best evidence is what he put on TikTok.
Well, I take the point. The point I'm making here, though, is this is a submission that went to the Secretary of State, which is setting out the basis for that first decision. And certainly the Secretary of State in the readout doesn't come back and say, well, that's not the reason that I took that decision. The reason was actually because I thought he was a mate of Putin's. That's not what the Secretary of State comes back and says. These are the departmental officials, and Mr. Driver was the key departmental official involved in the process, setting out this was the basis of the first decision. It was
They're not mutually exclusive, are they? I mean, the problem is Mr. Driver can quite happily say that he told the Secretary of State to take the decision for reason 1.
Yes.
But the Secretary of State may well have taken the decision for reason 1 and reason 2. Reason 2 being improper.
Yes, well, we then get back to Mr. Driver's evidence, which does say in terms that that was not, and this is 91, and he then comes back to it at paragraph 153 of his witness statement. That's at Supplementary Bundle, tab 383. He says in terms that that was not part of the decision-making process. So certainly his understanding, based on all of the back and forth that he has had with these in these ministerial submissions, that never formed part of the rationale for taking this decision.
He can say that it formed no part of his decision-making process. Can he say that it formed no part of the Secretary of State's decision-making?
Well, that's certainly his understanding, based, for instance, on the fact that here you have the department setting out the basis of the decision, and no one's come back to Mr. Driver and said, well, that's not the basis for the decision. So that's the first point. The second point is that you also have Mr. Driver's explanation for what was said, insofar as, and I take the point from Lord Justice Singh, that he doesn't suggest that he has spoken to the Secretary of State. He makes the point at 53 about the way that the term oligarch was typically used, and I appreciate I'm not being pressed on that point. But then at 88 to 90, he explains the difference between political messaging and policy making. But he also makes this point in the sense of that making reference to connections with Russia, even if there was some loose language, is actually not inconsistent with the rationale that's set out in the contemporaneous documents. And that's because of what was being said about people with extreme wealth, about the system of patronage, and the fact that it can be, and assumptions that can be made. So it's also not wholly inconsistent. But, and this is really to return to, or to come to the Master of the Rolls point. Even if there was some loose language, or as I think the Master of the Rolls put it, a mistake, or if the statement was false, and I should say, Sir Ross Cranston in his judgment does say it's untrue that he's a friend of Putin, says it in terms. But we say that's an error in the statement, but in light of the evidence of Mr. Driver, and in light, I would say, in particular of that April submission, and the annex to that April submission, we would say that's an error in the statement, but not an error in the reasons for the decision.
Well, what I asked you was, if it can be read back,
yes,
as they have said, they submit on the other side, and the decision is invalid, what is the consequence?
Yeah, well, that's my third point. So my third point is, if my learned friend is right, and you don't accept my first 2 points, we say it still doesn't assist the appellant. And that is really for the 2 reasons identified by my Lord Justice Singh in his exchange with my learned friend yesterday. So first, we say it's a pure historic interest, because just over a week later, a fresh decision was taken, and then a further decision was taken in early January the following year. So this is quite a unique case in that sense. The decision's already been reviewed twice, and there is no suggestion, and nor could there be any suggestion on the basis of the documents, that that first error infected the second and the third. So that's the first point.
But I mean, if the decision is invalid,
yes,
for the week while it stood,
yes,
that might have financial consequences.
Well, that brings me to the second point, which was made.
I will shut up, Mr. Bond.
That's okay. Which is that this is a classic makes no difference case, and there's a number of ways this could be framed, but in essence, evidence, if there was some procedural irregularity, it was not a material one. And because in contrast to many other cases where the government makes this sort of argument and it will often be said, well, where's the evidence? Where's the evidence of what would have happened? Here, you know exactly what would have happened because you have a decision taken in April that is not affected with the same alleged error. Now, I don't think there's any cases but I don't understand the propositions are in dispute. I do know that the relevant legal principles were recently looked at by Mr. Justice Jay in the Bagan case. But the test is, it's very straightforward. Would this have been, would the outcome have inevitably been the same if not for that procedural irregularity? If you do want the reference, it's 2023 Human Rights Law Report 6, and it's paragraphs 350 to 351. But it's a pretty uncontroversial proposition. And we say the clearest possible evidence as to what the outcome would have been are the subsequent two decisions. Now, my learned friend, when presented with these 2 points, gave 2 answers. First, he said, well, the reasoning in the first decision could have infected the other decisions. Well, that argument wasn't advanced in this appeal. There's no evidence at all to support it. So we say that goes nowhere if it is actually seriously being advanced. And second, he submitted, and I think this is the master of the rolls point, that, well, if you quash that first decision, his client might be entitled to damages for that 7 or 8 days. But we say, with respect, that misses the point because the argument about materiality actually explains why the court shouldn't quash that decision. So there wouldn't be a quashing because the procedural irregularity made no difference. It wasn't material. So you don't actually end up in, that's a practical reason why they would like you to quash it. But we say as a matter of principle, there's not a basis to quash on the basis that if there was a procedural irregularity, if you're against me on the first 2 points, it was not a material one.
Do you seek to uphold the comment made by Sir Ross Cranston that this was just political hyperbole?
Yes. And messaging, and we do, and we say that's
No,
consistent.
because I just put to you that it's not hyperbole at all. A falsehood is not hyperbole. It's actually a falsehood. I mean, if it were a falsehood.
Yes, and I would just invite the court to have a read of what, and I'm sure you've already read it very closely, as to what Driver says about how kind of the language of connected to Russia may well have been understood. But to be very clear, I'm not about...
We're lawyers.
Yes.
Mr. Podger.
Yes.
I understand we're not politicians, and
Yes.
Politicians speak an entirely different language.
Yes.
I get all that.
Yes.
But I just don't see how something that's not true can be called hyperbole properly. I mean, seriously.
I'll take the point. That's ground 4. Ground 5, I can deal with very quickly. And I'm going to make my target. And this is the appellants contend that the second decision, this is the decision taken in April, was in effect a holding decision. And that by failing to obtain further evidence, the Secretary of State had breached his Tameside duty. And the key point really rests on a misinterpretation of option A in the submissions. And I'm just going to very quickly take you to that. That is at Supplementary Bundle, tab 32, page 214. And you can see the options there. And so what my learned friend relies on is he says, well, this is saying maintain the detention direction while seeking further evidence. Now that has to be understood in the context of what was going on here, which is a few days earlier, and this is all set out in our skeleton with the references, a few days earlier, the appellant's legal representatives have written in and said, we want to make representations. They didn't make representations, they said, we want to make representations. And so what option A is saying is we're going to maintain the detention direction because we think the conditions are satisfied, and I'll make that point good in a second, because we think the conditions are satisfied, but we will take the further evidence and we'll consider it. Now, Mr. Driver explains at 103 that that's exactly what that option was saying. He says it in terms. Paragraph 103 of his witness statement, not cross-examined on, supplementary bundle, tab 3, page 66. So, but just in case there is any doubt, because the submission is effectively being made that at the time of the April decision, a view was taken that there was not a lawful basis to detain, and this was just, well, let's just hold while we go and search for further evidence. Now, the clearest illustration that is not the case is if you see the letter that was sent out after this decision was taken. The letter is at 223, and it's not entirely clear because of the way the bundle has been made up, but this letter was annexed to the ministerial submission in draft, but in the same form. But I think to avoid duplication for the court, it only appears one. So this is the letter, this is the email as sent, but it was also exhibited, well, it was also attached to the ministerial submission. And if you just look at the final paragraph of that letter, which is the letter that was signed off by the Secretary of State when he took the decision, accordingly, the Secretary of State remains content that the continued detention is appropriate and in accordance with the regulations. However, the Secretary of State would be happy to consider any evidence that Mr. Nemenko may wish to present in writing in relation to the continued detention. So that's what option A was. We say it couldn't be clearer. That's exactly what the judge found in paragraphs 82 and 89. We say that was in fact the only conclusion that was reasonably open to the judge on the basis of the evidence that was before him. There is a final and further difficulty with my learned friend's submission, which is insofar as it relies on Tameside and says that there was no further evidence obtained, and that is that those representations from the appellant were in fact received, and they were in fact considered. On the 26th of May 2022, the DFT received the promise reps from the appellant's legal representatives. That's supplementary bundle, tab 36, page 224. So James went through those. The only point that I want to make was that on the 14th of June 2022, I don't think you have been taken to this, so I'll just give you the reference. Supplementary bundle 37, page 241. The Department for Transport responded, saying we've taken them into account, but it hasn't changed our view. So the work was done, and then all of those further representations were also taken into account again in December, prior to the January decision being taken. So we say that disposes of ground 5. I've gone about 2 minutes over. I hope Ms. Plews will forgive me, but unless there's anything else I can assist the court with, they are my submissions.
I hope she will too, Mr. Popjoy. Thank you very much.
Thank you very much.
Ms. Plews.
My lords, my lady, it's common ground that the conversion issue only arises if the appellants succeed on any grounds warranted. Now, the court's familiar with the necessary ingredients of the tort already. The overarching position is that set out by Lord Nichols in Q8 Airways, which my lord referred to yesterday. I don't invite the court to turn it up, but it's the sideline passage at tab 12 of the authorities bundle, and the relevant passage is at page 551, paragraph 39. Lord Nichols there identifies 3 basic features of the tort. First, that the defendant's conduct was inconsistent with the rights of the owner. Second, that the conduct was deliberate. And third, that the conduct was so extensive an encroachment on the rights of the owner as to exclude him from use and possession of the goods. Notably, Lord Nichols there refers to excluding an owner from use and possession. That is the paradigm case conversion. It was against this backdrop that in the Van Gogh, which my learned friend Mr. Bethel took the court to yesterday, that Mr. Justice Flo found that a detention notice issued against a cruise ship on public health grounds did not involve a sufficiently extensive encroachment on the claimant's rights. The appellant's case is that the judge fell into error because in the Van Gogh, the cruise ship was only detained for a short period of time. And that was why there was no claim for conversion.
Do we have to be concerned with any evidence as to what actually happened to the vessel and whether the owner's representatives are allowed on board and so on?
Absolutely, access is a key metric to consider in relation to whether there's sufficient encroachment. And indeed, I'll come to access later on in my submission.
Okay.
But if for now I can ask your lordships and your ladyship to turn up the Van Gogh, that's at tab 21 of the authorities bundle, and specifically page 954. I'll take the court through the relevant passages that lead up to paragraph 53, which you were taken to yesterday, in which in my submission address both why the judge correctly interpreted Mr. Justice Flo's reasoning and why restricting the fee from sailing where it wishes doesn't amount to a sufficient encroachment. So if I can invite your lordships and your ladyship to start by reading paragraphs 40 and 41. Then move on from that discussion of the definition of the tort to page 956, that's just over the page, to paragraphs 46 and 47, Mr. Justice Flo here describes an important distinction that the authorities draw between possession cases and non-possession cases. I invite the court to read those two paragraphs.
I mean, I seem to remember Section 1 of the 1977 Act, which says trover is abolished.
Trover is the old name for conversion. It was
Well, no.
It was abolished.
Trover is a lesser form of conversion, used to be a lesser form of conversion, which is abolished.
My lord is absolutely correct in the sense that conversion has...
I mean, I may be wrong, it may be detenue, I've forgotten it completely, but the point I'm making is it not conversion to exercise rights of ownership without taking full possession?
It can be.
It can be.
Yes, absolutely, absolutely. So detenue is what is expressly abolished, but trover was a formerly old language before conversion expanded.
Quite
so
right,
we're
yes.
at slight cross purposes there. But
Sorry,
absolutely.
I haven't thought about this since 2000 and I think it was a long time before that. I think it was the 90s. Yeah.
Yeah. But no, it's no part of the Secretary of State's case that possession is necessary, but simply it's important to acknowledge that that's the paradigmatic case, and that we're stepping, for each step away from that, where there isn't possession, that does have ramifications for how far the court should expand.
And he says that.
Yes, absolutely.
Then what?
So that comes out, and this leads on actually to paragraph 48, which I'll ask the court to read next, which is where Mr. Justice Flo expressly addresses the decision of Howard Perry. The court could read that. those same reasons, and just a short point here, the same reasons as Mr. Justice Flo gave, we say that the point taken in my learned friend's skeleton argument, that there is some inconsistency with the judge below's approach and the analysis of Howard Perry, we say that's wrong, there isn't an inconsistency. And that's precisely because Howard Perry was a case where there was possession. So there were key factual differences from what was going on in the Van Gogh and in the present case to what was happening in the Howard Perry case.
Yes.
And then moving down to paragraph 49, Mr. Justice Flo focuses in on what the defendant's argument was, that even though the claimant remained in possession of the ship throughout, that the detention wasn't a physical detention as such, but it was an order which operated against the master and against the claimant. They weren't physically prevented from sailing the ship away in the next cruise, but to have done so would have potentially involved a criminal offence. That reasoning then leads on to Mr. Justice Flo's conclusion at paragraph 51, that he doesn't consider that issuing a detention notice can properly be characterised as a form of dealing with property. But he goes on in the alternative to say that even if it could be, his view is that the detention notice didn't in any sense deny absolutely the right of the claimant as the owner, and equally the defendant did not assert any right which was inconsistent with the claimant's rights. Before there can be conversion, he says, a defendant not in possession has to be asserting what some of the cases describe as dominion over the goods. That is, some right in relation to the goods which only an owner has. If I could then invite the court to read paragraph 52.
Yeah.
Here Mr. Justice Flo is recognising a situation where there wasn't possession of property by the tortfeasor.
When you sell the licenses, yeah.
Absolutely. But nevertheless, the way in which they dealt with property was such that he was asserting a key a right that would otherwise be that of an owner by selling the licenses. So that's the background against which we arrive at paragraph 53, which the court was taken to yesterday by my learned friend. And that's where Mr. Justice Flo, in light of his careful analysis of the authorities, concludes that nothing the MCA did here amounted to an assumption of ownership or dominion over the ship. The intention of the detention notice was merely to prevent the claimant from using the ship in a particular way, that is for the third May cruise, for a short period of time, and that was not conversion. As my Lord Justice Singh raised yesterday, there appear to be 2 points potentially in that sentence. In my submission, once paragraph 53 is read in its full context, which means in light of the preceding paragraphs, it's clear that the court's inquiry was focused on whether a notice restricting a ship's use amounts to the sort of dealing that assumes dominion and the sort of right that it may be asserted by such a notice. The question of how long that notice subsisted for didn't feature in the analysis of those authorities. In my submission, the judge's reading of the operative parts of Mr. Justice Flo's reasoning at paragraph 91 of the judgment was entirely correct. Having taken the court through the detail of that analysis, it follows that in my submission, it's clear why a situation like the present is insufficient to establish encroachment. The paradigm case of conversion is one of use and possession, submitted to your lordship. And it follows that where a defendant hasn't taken possession of property, it's one step removed from that. So establishing the necessary encroachment will be harder, and the court will be alive to how far to extend the boundaries of the tort. Here, of course, there's no dispute between us that Mr. Naumenko remains in possession of the fee. So absent that possession, the nature of encroachment must be such as to deny the owner's title to the property or be inconsistent with it in the sense of laying a claim to a right which only the owner has. The case law shows that's a high bar. So we've seen arranging the sale of property, which isn't your own, as was the case in the Douglas Valley case. That's clearly inconsistent with a true owner's right to property. Equally, preventing an owner from accessing their property, which is the point that your lordship made to me earlier. That was the situation in Oakley and Lister, which Mr. Justice Flo refers to. Now, in that case, preventing access to property is inconsistent with a true owner's possessory right to an ability to realise the value of a chattel.
But I thought they couldn't repair this ship. I thought they weren't allowed to repair it.
But no, that is also something that I'm about to address in response to my learned friend, if that's all right. Thank you. So in the present situation, where we come out at is that the intention and effect of the detention is to prevent Mr. Nalmenko sailing wherever he wishes, which is a restriction on a particular use, but doesn't of itself assume any right that is the owner's. No authority has gone so far as to find conversion on those facts. So turning now to the 3 points my learned friend made yesterday in support of his submission about the scope of the tort, the first was precisely that the degree of encroachment is significant because the fee's condition is deteriorating. He likened this to the situation in Howard Perry, where the steel, if it wasn't worked quickly enough, would become commercially useless. Now, in my submission, this is just not a Howard Perry situation for the following reasons. The appellants have never suggested that the fee can no longer sail. They've suggested that they needed snagging work done and repairs needed to be undertaken. In that respect, discussions about the logistics for undertaking repairs remain ongoing. In fact, once this was raised in the submission, in the request of the 1st of December 2022, it was taken into account in this third decision that the court has already been taken to. And in that third decision, it was recommended to the Secretary of State that he should consider plans for how such repairs were to be effected. And that remains the case today. That was part of his decision in January 2023, and discussions remain ongoing as to how that can best be achieved. But understandably, it's difficult to find proper berth which has all the necessaries for actually effecting those repairs. But there's absolutely not the case that there's been any prohibition on the repairs being done. Indeed, the Secretary of State remains open and willing to considering that, provided the necessary logistics and safety considerations can be taken into account. So that was my response to my learned friend's first point. The second and third points were ones of timing, namely that detention is indefinite and the duration has already been considerable. As to this, in my submission, the timing doesn't shed light on the prior question of whether the type of dealing assumes dominion or the nature of the right which is being asserted, and whether or not that's effectively the right that should belong to an owner. The type of dealing here is like the Van Gogh case, a restriction on using property in a particular way, and there can be no principled line that can be drawn between a 48-hour detention notice and one which lasts longer, such as 2 years as in the present case.
Well, it's all on the assumption that it's an invalid detention notice, right? So the whole thing's invalid on you, because otherwise we don't get to conversion.
Of course, but even taking aside, if we take out the detention notice from the analysis, the legal question that still must be asked is, what is the right that the defendant's allegedly asserting or usurping against the chattel? And in this case, there is no such right. It's simply a restriction on the owner's existing rights. So as against those points that my learned friend made yesterday, we emphasise that Mr. Nalmenko is throughout able to access the fee, he mans it with his crew. Contrast that with DFT officials who can't access the fee without master's consent or a lawful reason to go on board. That's Mr. Driver's first statement in paragraph 155. The reference that's supplementary bundle page 84. Mr. Nalmenko continues to be responsible for the fee, as demonstrated for his applying for licences for repairs, for maintaining and upkeep. And taken together, and in light of the authorities, we respectfully submit that that situation falls short of a sufficient level of encroachment to establish conversion. I appreciate I've taken that at a fair speed, but unless I can assist further, those are my submissions.
No, it's very helpful, Mr. Please. Thank you very much. Lord Anderson.
Lord, it's a pleasure to follow Miss Plews, as they say in Parliament. But I won't be up here for long, because I'd like to invite Mr. Birdling to answer the question that we were given by way of homework last night.
Oh, really not long. Mr. Badley.
Very short appearance from Lord Anderson. My lords, my lady, I'm, as Lord Anderson foreshadowed, going to deal with the essay question that your lordship set overnight concerning whether this court is required as a matter of principle to defer to Mr. Justice Garner's assessment.
I mean, are you doing the whole reply?
No,
For Shvidler?
I'm only dealing with that point.
Okay, essay question first.
To reassure your lordship and your ladyship, we have between us made sure that there will be enough time to allow this to be finished in good time.
Super.
And I can cut through a lot of this because, as I understand from the exchange this morning, it's now effectively common ground that this boils down to what Lord Reed's decision on behalf of the unanimous Supreme Court and abortion services did and did not decide. And while Sir James's starting point this morning was that the authorities really were from Reed onwards speaking with one voice on this point, as my Lord Justice Singh pointed out in argument, there had been a rather large measure of confusion as to what the lower courts were to do, the lower appellate courts were to do in circumstances where they were faced with a proportionality assessment from a lower court, whether to defer or were they to make the assessment themselves. And I think we also reached the point where Sir James accepted that that was the question that Lord Reed was attempting to provide some guidance on. And in fairness to Sir James, he'd say, query how effectively that guidance was provided. On what one might call the macro question, which I think was the exam question that the Master of the Rolls set last night, which is how does this apply in the run of public law cases? I don't actually think there's very much between us on this side of the court and Sir James, but I'll come back to that at the end and explain why.
Well, do you accept that in a factual case, a case where facts are in issue, if not the subject of oral evidence, like a care case or like this case, there is no ability for the appellate court to reconsider the proportionality balance, the 4 tests, unless the decision is wrong?
My lord, I don't accept that, no. And the reason I don't accept that is because, and this is where I'll come to on the macro question, is because, of course, when one is concerned with findings of fact, there's no magic about whether those findings of fact plug into a proportionality assessment or any other legal assessment. If the lower court has made findings of fact, then the appellate court must defer to those findings of fact, unless those findings were made in a manner that was wrong. But that's a different question to asking whether the proportionality assessment was wrong. And I say that follows from abortion services, because when one looks at how Lord Reed says that the wrong turn or the confusion or the overemphasis, however one wants to look at it, and read and what follows was taken, it followed from an elision of the conception of findings of fact and then how that played into the proportionality exercise. And his lordship said quite clearly, the assessment of proportionality is not an exercise in fact-finding. And that doesn't mean, as my Lord Justice Singh pointed out in oral argument, that there may not be a quite extensive fact-finding exercise for the lower court. There may well be. Judicial review there often isn't. But when you are conducting the proportionality exercise, what you are taking is the product of that fact-finding process. And you are, as his lordship said, interfacing that with quite sophisticated case law in different areas, and in some cases Section 3 and 4 of the Human Rights Act, and coming out with a result, a legal result, which is the proportionality assessment. So that is why I don't accept that the court has to, in a fact-finding case, limit its approach to cases where there is a finding that it is wrong, in the sense of there being some error, other than the conclusion that that binary conclusion, proportionate, disproportionate, is wrong. So I don't accept that. And that is rather that's the macro question.
But I don't completely understand, because if you accept that it has to be shown to allow the court to do the proportionality balance itself, that the proportionality balance has been wrongly conducted by the original decision maker, then you do accept what he says, because that's all Sir James is saying.
What I say is this: the proportionality, the outcome of the proportionality exercise, is a binary one. Something is either proportionate or it's disproportionate.
Yeah.
And if the court considers that that is wrong, the product of that exercise is wrong, then that is an error of law. That is a wrong. And there are different ways that one can analyse that in different contexts, and that is a different question from what the court was considering in RB. So I want to be very clear about why I don't accept that it follows from that the house is going to fall in.
Okay, let me put this to you. Let's say that there is an affidavit of Mr. Driver put before the first instance court, and the judge pulls out of that affidavit 3 facts on which, and there's an affidavit of Mr. Shvidler, and he pulls out 2 facts. And he says in his judgment, I rely on these 2 facts, these 3 facts, and I make the proportionality balance, and I come to the conclusion it's proportionate. And it goes to the appellate court, and the appellate court says, well, that's a legal question, and we think it might be disproportionate, and we're going to hear an appeal. Is the appellate court, limited to the facts on which the first instance judge has relied, or is that court entitled to look at all the facts again? Because if so, then it's doing both the factual and legal exercise of the proportionality balance again, just because it happens to have formed the judgment that the outcome might be wrong. And we need to know the answer to this question. So first instance judges know what they're doing. It's easy in the Re-B case, where there's been cross-examination of the mother and the grandmother and the carer and all this. Of course, the appellate court there will give huge weight to, and will only interfere with the findings of fact if they can be shown not just to be wrong, but to be facts really that no reasonable judge could have come to on the evidence. You see the point I'm making?
No, I quite accept that, my lord. And below, the way to explain how we are where we are in this case, of course, the claimant did invite Mr. Justice Garner to consider this and make factual findings on the basis of the evidence before him. But what Sir James said and what Mr. Justice Garner accepted was actually all the task for him was to assess the reasonableness of the Secretary of State's belief and whether there was.
Well, you
evidence.
said that, but he says not.
Well, it's what Mr. Justice Garner says in his judgment. Your lordships will read it and you'll conclude whether I'm right or Sir James is right. That is what Mr. Justice Garner says in his judgment, and that was what Sir James invited him to do. So we're not here in a position where Mr. Justice Garner did attempt to weigh the competing arguments and come to factual conclusions. He just said that the task for him was to assess the facts. But to take your lordship's counterfactual, because that's what it is, and assume that there were findings, I find on the basis of the evidence before me that actually a payment, this was the hypothetical that my Lord Justice Singh gave yesterday, a payment of £10 million was made if that was disputed.
Yeah.
Well, that's not something that could be upset on appeal unless one could do so in accordance with the normal principles.
No, but can you do the proportionality balance again on the basis that there may be other countervailing findings of fact the judge did not make that you are entitled to take into account? The judge needs to know what he's doing.
Well, my lord, that again would be a task that could be approached by reference to normal appeal principles. If you have a question of law and the judge has said, I've made these findings of fact, And 1, 2, 3, findings 1, 2, 3 are relevant to this legal question, but questions 4 and 5 aren't, and I put them out of my mind, or I say they don't weigh in the favour. If the appellate court concludes that actually question 4 and 5 are legally irrelevant, then the appellate court won't consider those. But if the appellate court considers that actually this question of law demands that those be considered because they're relevant,
There's a legal error.
there's a legal error. Precisely so, my lord. And that is why I say that it is a question that the appellate court really does need to grapple with.
But, I mean, that effectively means that the respondent, if it's the respondent, has to justify every decision on every case. I mean, it's very hard to know how you decide permission
Well, my lord,
without trying the case.
well, my lord, I need to grapple with that because Sir James has put that. It really is the roof will fall in submission, and I don't.
Sort of Damocles.
Well, I understand that your lordships and your ladyship are concerned about, the lists of this court, and that was what Sir James was really alluding to, that if every discretionary decision that involved a proportionality assessment would, as of right, which is effectively how high Sir James put it, end up before your lordships and your ladyship, the list would rapidly get full. And the answer is that that's wrong for 3 reasons. First of all, there are categories of cases, in fact, a rather large category of cases, that Lord Reid goes on to discuss from paragraph 34 onwards, where actually there can be a categorical answer. Alan Kane being one of those examples. Once you've got an authoritative judgment from the Supreme Court on that issue, you don't need to consider the individual facts of subsequent cases because you've got your decision. And Animal Defenders is another example that was given. The Strasbourg Court jurisprudence, including Animal Defenders, makes clear that you need a pretty strict justification.
Yeah, but this is not such a case.
This is not such a case, but this is one of this. We're sort of chopping down the categories of cases that might make it. So there's that, but then there's those cases where an individualised assessment is required. Now, there's nothing in abortion services that said that the key finding of Re B was wrongly decided. So it's certainly not the case that there is an Article 6 or other ECHR procedural requirement for there to be a system of appeals. So someone can't come along to court and say, actually, you can't deny me permission to appeal because there's no real prospect. Because actually, you've got to, because there's a chance you might come and make an assessment and it might be in my favour, you've got to grant permission to appeal. The normal CPR 52 permission to appeal conditions, assuming it's an appeal to this court, remain. So what this court will have to do is have a look and conclude if, in the same way that the court does with any other application for permission to appeal, there is a real prospect that if the court were to look at this again, a different decision would be made. Or, as in this case, as we saw from Lord Justice Lewis's grant of permission, there's some other compelling reason for this court to consider it. And I think your lordship, the Master of the Rolls, put it quite well this morning. You look and you see if there's an obvious error. Is there something that doesn't smell right? I mean, that is, your lordships, your ladyship will know much better than I, the process, the intellectual process of dealing with applications for permission to appeal. From my experience from this row, that seems quite accurate. And there's nothing in Re G or in abortion services that says that that's improper. That's what domestic law provides. And Strasbourg says if there's no need for, there's no convention reason why anything more than that is required. So the permission to appeal filter still remains, and your lordships will apply the normal principles that you apply. If you have a decision in a family case, for example, that followed a factual hearing before a family judge, where live evidence was heard, your lordship, your ladyship will probably think, actually, there's not really, unless there's something that's obviously awry, it's probably not really a real prospect that a different decision would be made. The position might be different, where, and I do say it is different, and I say we get this as a matter of binding authority. I'll come to that in a minute, abortion services, in cases like the present, where you have, as your lordship, your ladyship heard, a huge amount of discretion, the opposite of the animal defenders case, where Sir James accepts and positively advances a policy document in his submission can't even be prepared. So you do have in those situations, because of the breadth with which the legislature and the executive have prescribed the discretion, inevitably there will be more chance for differing opinions on appeal. And that's the reality. That's what Lord Reid was acknowledging in paragraph 31 when he was saying Bank Mallet is one of those cases where actually individualised consideration is essential. It's a consequence of the way that the discretion has been put at large, and it's the flip side, as I say again, of those cases where there are, in fact, care order cases are another example. You have a very carefully circumscribed number of questions, a processor, almost to use the master of the rolls terms, an algorithm that you follow, and that means that the room for arbitrariness and error is much less, and therefore the room for error on appeal. So that's what I say the second control on the roof falling is. And the third again is the factual findings. Because Sir James made a lot of stock of it wouldn't just be appeals, they would be de novo appeals. And you've got to be a bit careful about what that means, because again, in circumstances where you have had the factual findings being made, you won't be able to come along to this court absent satisfaction of the usual tests for fresh evidence on appeal and say, well, actually, there's all of these other bits of evidence that require you to go and revisit those findings. That's not what the convention requires. It's not what our domestic rules permit. And it won't happen. The error here, the reason why we're asking the court to look at this afresh is because, as you'll see, and this is pleaded as our Ground 1C, the judge below just didn't grapple with the actual questions that were before him, the factual questions, but rather limited himself to an assessment of the rationality of the Secretary of State's belief. So that's what I say about the exam question, the macro question. What I say about the micro question, about how it applies in this particular case, is that they're actually a much simpler path through. And that is that whatever Lord Reid did or did not decide in abortion services, it is that in a case like Bank Mallet, on which I say this case is on all fours, you do have to conduct an individualised assessment. And you get that from paragraph 31, where the Bank Mallet case is identified explicitly as being one of the cases where you don't defer to the lower court's assessment. And then again at the end of paragraph 33, which is where the court is addressing what one might call the wrong turn, or perhaps the turn that had been overemphasised or misrepresented in other cases, read B, and says that you shouldn't place too much reliance on those cases without looking at the cases that I've referred to at paragraphs 29 to 31, which include Bank Mallet.
So in a normal judicial review case involving a proportionality exercise, you say this, do you? The rules are the same whether what is being questioned is a policy, a rule, or a decision. See Lord Reid.
I do.
You do. And when the case comes to the Court of Appeal, the Court of Appeal will give permission to appeal if there are reasonable grounds for thinking, taking everything in the world into account, that the decision was wrong. In other words, the outcome was wrong.
My Lord, I wouldn't accept taking everything in the world into account, because it would be taking into account the admissible evidence.
No.
And the findings. But
Of course, the
all of
admissible
the but I do say that that's important, because Part of the concern is, obviously, this could get, if at every stage of the hierarchy you could introduce more and more facts. But yes, I do. Having regard to, and I do say it would have to be having regard to what was put before the judge below. Of course in
a normal judicial review case where there's no cross-examination, there's a load of evidence, you say that so long as you can show there's reasonable grounds for thinking you might be successful in showing the decision outcome was wrong, the appeal goes ahead.
My lord, yes.
And when that appeal goes ahead, the court's job is to conduct the proportionality exercise, again, paying due weight to the way the judge did it. And you also perhaps say that Sir James won this case, but when the government's the appellant, he might feel differently about how stringently he wanted to confine the exercise.
My lord, yes, the principle cuts both ways.
The principle cuts both ways.
Of course it does, because it's a question of law.
But you say a different rule would apply where oral evidence is heard and where a proper fact-finding has occurred, as opposed to simply relying on a panoply of factual material. Do you?
It might, and the reason I say it might is because, again, the reason why it's going to depend on what the facts are and why they are relevant.
Well, if in that situation you want to show that the outcome was wrong, because for a factual reason, but for a balancing reason, you have to show, do you, that no reasonable judge could have failed to take into account facts A and B, and taken into account facts D, C, and E.
I do say that, and that's why I appreciate your lordship is looking for a rule, but the reason I have some sympathy for what Lord Reid was doing is because different tests in proportionality are different in different circumstances, and the extent to which the facts as found are going to be determined.
You see my problem with your submission. My problem with your submission is that is a distinction without a real difference, because the judge has made an evaluation of the facts that were before them. The judge makes an evaluation of the facts before them at first instance, and it really matters not whether those facts are contested, i.e. the extradition cases or the care cases, or they're not contested because there's not much point, as in this case.
Well, my lord,
as a matter of intellectual justification.
I accept that, and that's why I say the ultimate question always is going to be, in all of these categories of cases, whether there's a real prospect of reaching a different view on the proportionality assessment. Now, the reason I say that there's a difference in some of those cases where factual findings are made is that in some of those, indeed probably very many of those cases, the factual findings are going to be the necessary building block to overturning that proportionality assessment. For example, real risk on return, if it's an extradition case, that might be an example. If there's no real prospect that you're going to overturn that factual finding, then it will follow that there's no real prospect of overturning the proportionality assessment. And it will be the same in very many family cases. And that is where I have a lot of sympathy for Lord Reid with the trying to square the circle, because it really is, I think, there where the difference between those categories of cases comes in.
But in this category of case, which you say there is effectively, it's open on appeal once you fail the smell test to start again.
I do.
I mean, that's a big change in people's understanding of the role of this court.
Well, my lord, I say it follows for the reasons that were set out in paragraph 30 and 31 from those authorities. That is the principles that was established in Belmarsh. If your lordship, your ladyship, read Bank Malad, what the court was doing in quite clear terms, including Lord Reid, was explaining the task for the courts, and then the court there, the Supreme Court, and
you rely on Lord Sales in Zeta and say that Lord Sales' view was really approved by Lord Reid, in effect.
I don't go that far, because he doesn't, and and I can't fairly say that he does.
No, but he certainly prefers the approach of Lord Sales
He
to
does.
the approach of Lords Hamblin and Stephen.
He does. He does. And that's why I say, for the purposes of this case, what he is certainly saying, even if there is...
So you say this is a really important case.
I do say it's an important case.
I mean, and not that we doubt that, but I mean, it's just...
No, but I say this isn't some unorthodox position, because what this is doing is returning to what both Lord Sumption and Lord Reed said in Bank Mallet, that when you have a case like this, you actually do have to. I mean, they both use the language of exacting factual analysis, and they did it in that case for good reason, because you're in the same situation you're in here. Very broad discretion. And when you've got very broad discretion, and Parliament hasn't given you much in the way of legislative framework for how you exercise that discretion. So James says, don't even need to have a policy, can't have a policy. The room, the disagreement about how you balance them necessarily is high. And the system that we have of appeals in this jurisdiction, because we're here dealing with the wrong test, so we are dealing with a domestic law question about what in this jurisdiction we've said about the scope for error correction, is that the Court of Appeal is more competent to decide on those questions than the High Court, and then the Supreme Court more competent again. And that is a domestic law choice that has been made. We could have done it, Sir James says, in other convention countries, where you don't have a right of appeal. So you've got your original decision, and then you're stuck with it, because your jurisdiction hasn't decided to have that error correction mechanism. And I say error correction mechanism because, of course, when you're in convention territory, what you're asking is there not a breach of the convention? If it's disproportionate, there is. If it's proportionate, there isn't. And what the Supreme Court and Bank Mallet are saying is, because of their constitutional role, and this is repeated in abortion services, it's actually for that court, not having looked at it and decided, well, actually, I think this is disproportionate. I think there is a breach of the convention, but actually they're bound by some concept of deference to actually say, but I wasn't the judge below, and I won't overturn it. And as a matter of domestic mechanics, that's because I say wrong in that context means a wrong decision has been made on what is a legal question, which is proportionality.
I put to St James, to Sir James, not St James. I put to Sir James that it all turned on what was meant by it's wrong. And it seems to me that you two are not saying anything very different about what it means to say it's wrong, except that you basically say that the factual situation, all the elements of the factual situation can be taken into account to conduct the smell test at the permission to appeal level. And Sir James, I think, would say you have to get your screwdriver into the factual findings and say there was a legal error, in other words, legal error in not taking into account another fact, or a legal error in taking into account a fact. Is that it?
I think so, and I think actually we might not be that different there, because it's just about whether, as I say it's the case, actually the conclusion that fact was relevant to the balance is a legal error, because ultimately the decision about proportionality is a legal question.
It still means that you get an appeal in most cases if the smell's wrong.
If the smell's wrong, my lord, yes, and as a matter of policy, I would say that's no bad thing, because what this court is tasked with, amongst other things, is correcting errors in lower court judgments, and what you have sniffed, if you think the smell is wrong, is a potential legal error on a question of proportionality, and that is of no less importance than any other legal error that your lordships and your ladyship might come across in other areas of the law, private or public.
Okay, thank you.
Lords, I start sublime to the ridiculous with a factual point on licensing. My learned friend suggested the licensing power under the Act and the regulations was a substantial safeguard, but that in our submission is not at all how the evidence comes out. May I deal with a few specific points that my learned friend made? The first was the issue of general licenses that apply automatically to everybody without the need for a specific application to be made. There are a number listed on the OFSI website. I had a look this morning. Most of them are quite specialised. They're things like licenses to continue to provide legacy trust services to someone who's under trust services sanctions, that sort of thing. There is a general licence for the payment of legal fees, but there is no basic needs general licence. So there is no general permission simply to take money from your bank account to go and buy food. School fees, again, there is no general licence. The evidence regarding the schools is that Mr. Shvidler's first and second witness statements, supplementary tab 5, paragraphs 157 to 160, page 66, and supplementary tab 13, paragraphs 307 to 310. The Shvidlers were simply informed by the schools that their children were being compulsorily removed by the schools, one on the 28th of March and one on the 6th of April. The documents that were before the learned judge included a letter to that effect from the Board of Governors of Harrow. It's not suggested, nor could it be, that it would have been lawful either for Mr. Shvidler or for his wife or for anyone else to pay the fees. You'll remember the anti-circumvention provisions in Regulation 19. And the suggestion that a licence could have been obtained is said by Mr. Shvidler to have been contrary to OFSI policy at the time, as my instructing solicitors understood it, and something that would have been anyway far too time-consuming to achieve given the need to find the children's school places for the summer term. And Mr. Reid, those points are made in the second witness statement of Mr. Shvidler. They're not engaged with in the second witness statement of Mr. Reid. Finally, on licensing, and in relation to licence delays, I refer to our skeleton argument below, core bundle, tab 9, page 130, at paragraph 70, where there is treatment of the issue of delays in the issue of OFSI licences. And it says, these delays, I should say the skeleton argument was written in July of 2023. These delays are widely recognised to be endemic, and official figures are cited from Mr. Shvidler's witness statement, revealing that despite the fact that more than 1,000 people and entities had been designated under the Russia regulations in the first 6 months of the war, and 642 licence applications submitted, only 11 specific licences had been issued by OFSI under the Russia regime in the same period. And the claimant's own negative experiences are noted. My friend says, well, why don't you judicially review OFSI? Well, Mr. Shvidler did get as far as issuing 2 pre-action protocol letters against OFSI to try and hurry them along for various reasons. So if my friend wants to rely on licences as a mitigating measure, then fine, but one has, in my submission, to look at the realities on the ground and not just at the position as it might appear on the page. But Lords, Milady, there were other aspects as well in which guardrails are missing, and that we say is a factor which should incline the court to particular vigilance, given the consequences of these sanctions for the individual. And all of those are evident on the facts of this case. I'll just pick up a few points arising from my friend's submissions on that. First, there's the sheer breadth, point I made in opening, of the eligibility for sanctions, which inevitably means that many people will fall within the potential scope of sanctions whom there is not even the beginnings of a public interest in designating, let alone a suggestion that designating them might have the slightest effect on the war in Ukraine. So the phrase obtaining a benefit from or supporting the government of Russia sounds unobjectionable enough until one sees how broadly it is defined in Regulation 6.4, companies in any of 9 sectors of great strategic significance. And not only, a point I missed in opening, is I took you to the regulation but didn't make the point, it's not only being an executive or non-executive director of those companies operating in those sectors, it's being a manager as well. And then, of course, is associated with, and based on the concept of financial or material benefit. The government appears to think that this applies to any benefit, even if granted for good consideration. One gets that from the SDF, revised SDF supplementary 7104, where they list various things Mr. Shvidler has said in his own statement and say these all appear to be financial or other material benefit. If that's right, then anyone who has ever supplied goods or services to a prominent Russian business person, no matter how long ago, whether as an estate agent or a provider of schooling or a financial advisor or, heaven forbid, a lawyer, would satisfy the statutory designation criteria. Then, Lords, you have reasonable grounds to suspect, which, as my learned friend rightly says, paragraph 10 of his skeleton does not require the Secretary of State to make factual findings on the balance of probabilities. I've shown you Ahmed, and you see the centrality of this test in the current scheme, again from the revised SDF at Supplementary Bundle, tab 7, page 102. All the findings of fact are prefaced on that page by the Secretary of State has reasonable grounds to suspect the following. And you see in practice the latitude which the government takes from that to find its criteria satisfied, even when there's contrary evidence. So reasonable to infer a financial benefit from Mr. Shvidler's chairmanship of Millhouse, even when there is evidence from him, not contradicted by Mr. Reid, that he was not remunerated in that role. Reasonable to assert ownership and control of Evraz, even when you have the leadership agreements, you have before the court the relationship agreements and the witness statements from other directors, including Sir Michael Peat and others, verifying the independence with which they operated. So that's just a demonstration of how considerably that is seen by the government as enabling them to put these cases together. And on top of that, Lords, my lady, there are two other risks for any designating body in this specific field of country sanctions. And we say both are in the background here. One is the risk of unconscious bias or indirect discrimination. And I've shown you or referred you to the evidence about Mr. Looney at BP, the BP joint ventures with Russia, some of them a very recent date, and you've seen the position of the other directors. There was no answer from a learned friend to the point that the objective justification that is asserted for the different treatment of the directors with different national origins lies in the receipt of a material benefit from Mr. Abramovich. But as you see from paragraph 104 of the judgment, accepting the Secretary of State's submissions, anyone who was a director of Evraz, according to the Secretary of State and the judge, was in receipt of a financial benefit from Mr. Abramovich. So that distinction is, on their own case, illusory. Well, the second factor in the background is a temptation to stretch the boundaries for political reasons. Of course, one of the functions of sanctions is to send a message that this country strongly opposes the invasion of Ukraine and will inhibit those who promote and sustain it. A degree of publicity is part and parcel of the nature of sanctions, and no doubt that is why Regulation 8.2 places the Secretary of State under an obligation to publicise designations. But the data subject access requests, we suggest, in the supplementary bundle at tab 1, give a very interesting insight into how Mr. Shvidler, who is a very untypical target of sanctions, came to be designated. And I'd refer to the speed with which the sanctions were put together. Initially, it would seem as a means of justifying the detention of a plane for whose detention there was no other justification. My friend said that it wasn't as fast as all that. Well, looking at those documents, on Thursday the 17th, the officer view was that Evraz was not even within scope. On Friday the 18th, the teams were working up a case. On Saturday the 19th, in the evening, they were under pressure to issue sanctions over that weekend, and the final designation happened on Thursday the 24th. Then, still under this head, there were the tweets from Mr. Shapps, which, in the words of the Master of the Rolls, were not hyperbole, but falsehoods. And they were eventually a year later withdrawn.
I wasn't suggesting a view.
No. I was only using
the point.
I didn't mean to embarrass the Master of the Rolls. I was simply borrowing his words. But I have no difficulty in applying those words to those tweets. All this supports our submission that the initial designation was a politically led initiative, and really the very opposite of the cool and considered exercise that is described at 4.2 of the respondent's skeleton argument. And why there was, as my friend started his submissions by saying, a reconsideration, which we initiated as soon as we received the reasons in June, the thing that was reconsidered in practice was the issue of whether the criteria for designation were met. The section on proportionality remained in boilerplate form in the revised designation of November, and the degree of thought given to that can be seen from the failure in that section to recognise not the fact of Mr. Shvidler's British citizenship, but the consequences of his citizenship when he was abroad. That's supplementary tab 7, page 106. And although my learned friend sought to downplay that fact, he did not deny that that was indeed the implication of the way the SDF was drafted. Lords and ladies, one way of improving the position, as I submitted in opening, would have been to have in place a policy or guidelines, and it is indeed remarkable that no policy was in place, if not by the initial designation shortly after the invasion, then at least by November when the designation was confirmed in its amended form. There was a suggestion from my learned friend that my submission on the absence of a policy was a new one, not mentioned below, but on the contrary, it was advanced in very similar terms before Mr. Justice.
I think he said it was a bad one.
We said it was bad too. He also, yeah. Well, if it's bad, it's doubly bad, because I had provided my friend with we had a transcript in the court below. I don't know why we did that, but not here. But there was a transcript in the court below. I've shown my friend the relevant extract. What I said then is what I say now, that I do not suggest that the absence of published guidance is in itself enough to invalidate all designations ever issued, which would be an ambitious submission. It is undoubtedly a factor which increases the risk of arbitrary decisions being taken in particular cases, and indeed may so have contributed in this case. I assume I invited my friend to withdraw his submission that my point on this had not been made below and was being illegitimately introduced. I don't think he's really going to maintain it because he's seen the transcript.
I don't think it matters.
I think he's lost interest, possibly. Lords, this is entirely consistent with the case he mentioned, didn't take you to, the case of R against A, 2021, Weekly Law Reports 3931. That was not a case about the consequences of there not being a policy, it's about when a policy might be found to be unlawful at common law. And indeed, the Supreme Court reinforces the point made in Lumber that I cited to your lordships. What we say in this context is not that there was a legal obligation to have a policy within a few days of the sanctions regime coming in, but that where a discretion is as broad as this one, the government proceeds at its own risk if it chooses not to have guidance. And the risk is one which eventuated in this case, the risk of arbitrary and disproportionate decision making. My friend suggested it would not have been practicable to produce guidance, but it's not difficult, in fact, to think of what guidance could have looked like. It could have set out the government's understanding of contested phrases, such as associated with, and financial benefit or other material benefit. It could have sought to categorise, however roughly, the full spectrum of people who nominally qualify under the regulation, from Putin's inner circle to those who actually stand some chance of influencing the conduct of the war in Ukraine, to people who are substantial business figures in Russia, and those who are caught as a bycatch, as the fishermen say, because of some incidental connection, perhaps with a person who's involved for other reasons. That might be a useful exercise for the purpose of winnowing down the number to the proportion for whom sanctions could remotely be considered appropriate. And significant features surely would be whether the person lives in Russia, whether they are active or have recently been active in Russian politics, whether they are Russian citizens or indeed British citizens. And it could have indicated the factors that could form part of the delisting policy criterion. This issue began when somebody else, Lev Kassis, was delisted, who hadn't condemned the war in Ukraine, who had a very senior position in a major Russian bank and who was a Russian citizen. And we didn't understand why. We said, where's the policy that you applied? One could have guidance in which it will be asked, has the designated person ceased having any commercial activity in a sector of strategic significance? Have they divested from Russia completely? Is evidence of a clear commitment to the UK? Have they criticised the actions of the Russian government? Are they prepared to allow a periodic audit of their finances? Are they prepared to provide support to Ukraine? Well, there's none of that, and that explains the terrible limbo in which Mr. Shvidler feels himself to be situated. On associated with, there were 2 points. One was the issue of associate of an associate, which you have our submissions. My friend said really nothing about it. The other is the ambit of the phrase as defined in Regulation 6.6, which I suspect is an issue of some general importance. So I'd like to come back on that in a little bit of detail. The Secretary of State has raised his ambitions on this. Whether you look at the designations and the designation and the reason for it, or if you look at my lawyer friend's skeleton argument below, you see no reference to the point that is arguably being made by the learned judge at paragraph 98. I accept with less than perfect clarity that you don't need to find financial or material benefits so long as there is a friendship or a business relationship. And you've seen the enormous efforts that were made to establish financial benefit through the meaning of joint arrangement and company law and so on. You might wonder why it was necessary to bother doing that if a friendship or a business relationship were enough. The court has my points on the legislative materials. in particular the explanatory notes at tab 52, page 2253, stating that amendment to include immediate family members was to broaden the definition of associated with to include specified immediate family members, and my friend's submission that non-specified family members are included within the definition is flatly inconsistent with that. And in relation to what my friend said about the interpretation of this clause, I would refer to two well-known principles of construction. The principle of legality, which among other things requires fundamental rights to be, requires legislation to be construed in a way that is in accordance with the law, where fundamental rights are concerned. Citizens must be able reasonably to foresee the consequences which their actions may entail to allow them to regulate their conduct accordingly. And then secondly, the principle which I'd better not express in Latin, that the express inclusion of some matters indicates that the drafters were aware of similar matters and chose to exclude them by design. It's perhaps not quite as short as the Latin would have been. Yes, the word includes normally means that the factors that follow are non-exhaustive. But where the factors that follow are as specific as they are here, it is a fair inference that the drafter was simply being careful to include situations that might have been on the borderline, rather than intending to include factors of a wholly different nature. As to that, take the example of family members. Regulation 6.6 states that associated with includes being an immediate family member, and an exhaustive list, expressed to be exhaustive list of immediate family members, is set out in Regulation 6.7. What would have been the point of that if, as my learned friend contends, family members not falling within that definition are included anyway in the concept of associates, his great-grandson, for example. And in the same way, when it comes to financial or business relationships, what the legislator had in mind is expressed in the phrase obtaining a financial benefit or other material benefit from that person. They're quite specific words. They're expressly limited to material benefit, not to the offering of a career opportunity or the pleasures of friendship. So the same principle in our submission applies. Synesis. My friend quoted from the document at supplementary bundle page 41, it's tab 5, which is a letter from Peters and Peters, the July letter from Peters and Peters, paragraph 36, the effect that Mr. Shvidler received a severance package in the amount of approximately $10 million in accordance with his employment contract. But he did not take you, and I won't take you now for reasons of time, to paragraphs 37 and 38, which make it clear that he was an independent investor in a number of companies while he was president of Sibneft, that the returns on his investments are the source of his wealth, and that prior to the sale of Sibneft, Mr. Shvidler appeared at number 321 on the Forbes list of the world's richest people, which I understand assessed his wealth at more than $1 billion. So when Sir James then said, according to my note, though that benefit was received in 2005, it has had lasting significance for the development of Mr. Shvidler's business interests, we say that that severance package is a red herring for a variety of reasons. It wasn't a financial benefit from Mr. Abramovich. It wasn't the source of Mr. Shvidler's wealth, although that's an irrelevant consideration anyway. And since it long predates even the invasion of Crimea, even if it were a financial benefit from Mr. Abramovich, it would fall, as I submitted in opening, firmly within the category identified in Synesis, tab 40, page 1900, paragraph 25, of situations in which involvement has not been recent and which should not form the basis of designation in any reasonable exercise of discretion. Lords, on the authorities, I've made my submissions rather fully already, you might think quite fully enough, so I would make just a very few points. Belmarsh, yes, it involved established discrimination, as my friend put it, but there were separate findings, indeed separate sections of their judgments relating to disproportionality and discrimination in the judgments or speeches of both Lord Bingham and Lord Hope. On Lord Carlisle, my Lord Justice Singh had 3 points on paragraph 34, which he was good enough to share with us on page 1488G. A friend wanted to add one. I would like to add one too. I would go a little higher up that paragraph, between E to F, where it is said that the court must test the adequacy of the factual basis claimed for the decision. Is it sufficiently robust, having regard to the interference with convention rights which is involved? The case of Phillips, Mr. Justice Johnson, my learned friend very successfully, sorry, who was counselling first? Yes, it was in fact my learned junior, Mr. Birdling, who's a very versatile advocate, and he very successfully in that case asked the judge to apply the reasoning of Mr. Justice Garnham, both on the standard of review and what I've called the collective rational connection heresy. He was successful, but Mr. Justice Johnson was wrong in that case, just as Justice Garnham, we say, was wrong in this one. So far as the judgment under appeal is concerned, it's true, as my friend said, that Mr. Justice Garnham reproduced the passage from Lord Carlisle, paragraph 34, that we cited to him, paragraph 88 of his judgment. We considered it so important, we set it out in extenso in our skeleton argument. But it didn't stop him falling into error at 91 to 92, perhaps because he also heard the submission of Sir James recorded at paragraph 135. My friend tried to give you a coherent reading of 91 to 92, but in my submission he didn't succeed. 3 points are clear. 191 presents a false dichotomy. Secondly, at 91 to 92, he devoted close scrutiny not to the facts, but to the issue of how far he should defer. And thirdly, he went wrong when he said at 91, echoed in 92, that he should limit himself to asking whether the decision was properly open to the executive. And you see that being not just said, but done, when you turn, as my Lord Justice Singh drew to the attention of the court, to paragraph 131, not self-evidently irrational or outside the range of reasonable responses, and 135, entitled to include. Lords, on the issue of the decision that was improved or supplemented after the date it was taken, Lord Justice Singh mentioned the authority of misbehaving for the proposition that it can be about the degree of weight to be given. And the passage he may have been referring to, again I don't take you to it, is at it's tab 19, page 865, paragraphs 26 and 27. That was the case, of course, in which the human rights considerations were never considered at all by the decision maker. This case, in a way, we say, is even stronger, because the issue of rational connection was considered when the designation was made. You saw those 3 ways in which it was put, sending messages and signalling and so on. But the factors now insisted upon as relevant were not referred to at all. The whole issue of intermediary influence emerged from the keyboards of the officials and lawyers who were tasked with revisiting this issue for the purposes of the litigation. Furthermore, we know these new factors were not based on any new evidence because we were told that in the response I took you to, I think it's supplementary tab 12, to our request for further information. And we have seen, and the court had seen, the evidence on which the old factors and therefore the new factors were based because nothing was withheld from the court. That includes the evidence on Mr. Abramovich, of which the rather faded highlights were summarised by the learned judge at paragraph 111. It's not just about closed material procedures. Had the government wished to rely on intelligence or other material that was confidential or secret, then Regulation 8 made careful provision to allow this to happen. Regulation 8, you may remember, requires in normal circumstances the Secretary of State to inform the designated person of the designation, including the statement of reasons, and to publicise it. That's Regulations 8.2 and 3. But if you read on to 8.5, you see there is a power to exclude from the statement of reasons material that the Secretary of State relies on but considers should be excluded in the interests of national security or international relations. And access to court is preserved, as Lordships have heard, so far as possible, by the availability of the closed material procedure in Section 40 of SAMLA. Neither of those powers, the power to exclude nor the power to invoke a CMP, has been used in this case, and that's how we know that the court has before it the totality of the evidence relied on and referred to in the government's response. And all those, we say, are relevant factors when it comes to addressing the question that the court identified at the start of 92, the extent to which it should defer to the expertise of the Secretary of State and the extent to which it can itself form a judgment. Particularly in addressing the rational connection limb that was also identified in that passage, the contention that the claimant's designation could contribute to achieving the objective. And with respect, my learned friend did not really say anything that wasn't in his skeleton argument about the 8 factors, which I developed yesterday in opening. The general approach seems to have been, you never know. There might have been some effect via the highly indirect, speculative and unparticularised suggestions that were made under those 8 heads. And as my learned friend said below, no one is capable of knowing how those lines of influence might develop. One just simply does not know. That is a long way, we say, from capable of contributing systematically to the desired objective, the burden being on the Crown, and contributing, at least, to achieving the objective. On fair balance, the wrong test, as we say, was applied at 135, entitled to include, and the collective fair balance test also vitiated the decision, and the failure to consider whether he would be more adversely affected by being a British citizen. And I've made that point. Finally, Lords, temporary and reversible. It was said that this was a conclusion the judge was entitled to draw. A distinction was made with the confiscation case. Well, Lords, it's plainly not temporary. As Lord Justice Popplewell and the Chancellor said in Boris Mintz, it's a misconceived borrowing from a different system. And the friend continues to rely on ES, but the paragraph he cites, 209, specifically refers back to 79, where it's made clear that the freezing applies for a specified period. That's why it's temporary. And nor is it reversible. I was imagining if one ever had to sentence someone to imprisonment and to cheer him up said, well, don't worry, the sentence is reversible, by which I mean you will someday be let out. That's not reversible. And Mr. Shvidler is, in a sense, a prisoner, an economic prisoner, but also a man who's had his reputation stripped from him. That is real, but the objective advanced for designating him, we say, is illusory. So we ask you once again to quash this designation. I'm very grateful.
Thank you, Mr. Bevan.
My Lords, my Lady, on the legislation, Sir James made the point, and Mr. Pobjoy picked it up as well, that there are a number of amendments that were introduced over time to Part 6 of the regulations. That's absolutely correct. What it is necessary to focus on, however, is the amendments that were in place at the time that Regulation 57D came into effect. And at that time, the measures that were introduced with that related to restricted goods, dual-use technology, infrastructure, and infrastructure-related goods, and energy-related goods. And my submission is that that's indicative of what Parliament had in mind with those shipping provisions. So the extent of the trade measures that were being adopted at that stage were focused on those particular sectors of the Russian economy. And so my learned friend's point about Parliament ratcheting up the measures over time obviously is susceptible to more than one analysis, because if it was necessary to do more later, well, that is perhaps indicative of what was understood to have been put in place earlier. On ground 3, stating grounds, Lord Justice Singh took the point up with my learned friend Mr. Pobjoy about the point that as a matter of public law, if there is a statutory requirement to do something for a valid notice, that requirement ought properly to be met. And the form over substance point that my learned friends take from the Van Gogh, we say, is, in our submission, not good enough. On the question of reasons, I can see my Lord, the Master of the Rolls, raising a quizzical eyebrow about what I mean by not good enough.
Well, I mean, it's either wrong or it's right.
Well, the point that I make is simply this, that there is ample public law authority, which I apprehend Lord Justice Singh had in mind, about the requirement to meet a formal requirement that's set out in a statute. And if it's not there, well, to say dismissively it's form over substance is no answer to that. On the question of reasons, the point's been made a number of times that there's been no cross-examination sought or pursued. Cross-examination, of course, is always highly unusual in a public law case, and here we arrive in this court from a modified Part 54 judicial review procedure. The reason why cross-examination is so unusual in that context is because the parties rely upon the duty of candour and the conspicuous care with which witness statements are prepared in public law litigation. That is a point that has been referred to many times, including in a judgment of Lord Justice Singh in the Poirot case, in which he refers to the conspicuous care. The neutral citation for that is 2018 EWHC 1508. It's a divisional court judgment. Now, one of the points that is identified there by reference to Northern Ireland authority is that there is, as the authority puts it, there is no place for what is in modern parlance called spin in a public law witness statement. Now, what one takes from that, in my submission, is how to approach a witness statement that has properly been put before the court in proceedings of this sort. That does not mean that the court is required to give the most favourable possible interpretation of what appears in that witness statement in the absence of cross-examination. So when Mr. Driver says, and we've seen this example a number of times, that the reasons given on the key side, those statements do not fully reflect the reasons for the decision, then the court can properly take that at face value, as meaning that they do reflect in part the reasons for the decision. If Mr. Driver says, as he does at paragraph 91 of his witness statement, the paragraph that Lord Justice Singh drew attention to yesterday, if Mr. Driver says there that the statements made by the Secretary of State were consistent with the rationale in the 8th of April document, and then continues to say that the first detention decision was not taken for any reasons other than those set out in writing, then the court does not need to hear cross-examination to conclude that evidence does not add up, and that it can only mean either, as I suggested yesterday, that those reasons given by the Secretary of State on the key side are in fact reflected, as Mr. Driver puts it, in the April detention decision, or that his evidence is wrong on that point. Those are, as I suggested yesterday, the two possibilities. Lord, the Master of the Rolls, is respectfully quite right to say that what's being talked about in terms of hyperbole is, in reality, what ought properly to be described as a falsehood. And so in that context, my learned friend Mr. Pobjoy's submission that, well, it doesn't matter. If those things hadn't been said, that the decision would still have been made, is, I mean, it might be said a thoroughly unattractive conclusion. It might be said that doesn't matter. What does matter is that it's not so easy for Mr. Pobjoy to avoid the consequences of that by saying, well, this is a classic, highly likely, not substantially different case, because that is a statutory provision in section 31(2)(a) of the Senior Courts Act, and does not apply, so far as we understand it, in this sanctions review context, where the court applies the principles on judicial review. But that, in my submission, does not extend to.
I don't, forgive me for interrupting you, but I don't think it would be right before the end of the hearing to allow you to proceed on a false footing. I may be wrong, so please correct me, but I had understood that even before section 31 of the Senior Courts Act was modified in 2015, yes, it was, at common law, it was always the position that if an error in the decision-making process is not material.
Lord, yes.
And now it's been modified in the sense that something slightly less is required, which is that it's highly likely, it doesn't have to be inevitable. But here, Sir Ross Cranston, as I read him, said that it would not have affected the outcome. And I'm not sure that depends on a particular statutory regime.
Well, my Lord may well be right on that, and I would respect that. Thank you. As to the point, though, that the fee would have been captured both literally and metaphorically by the April decision had the wrong decision not been taken putatively in March. The fee was intended to leave London by the 8th of April. Captain Booth gives evidence of that in his witness statements, supplementary 110 for the court's note, paragraphs 14 and 15, supplementary bundle 4, page 86, paragraph 6. As to the nature of the decision, the court was taken to page 222 of the supplementary bundle as showing that the Secretary of State adopted retrospectively, and it can only be retrospectively, that rationale document in April. Of course, I rely on that very same short email from the private secretary as showing that this was about the express terms of option A the Secretary of State was adopting, which of course were detain while we make further, while we seek further evidence. On conversion, the London Trocadero case is helpful for the authorities that it contains within it. That says Authorities Bundle tab 24 at page 1247. And all I take from this is the two authorities that appear on that page, Oakley and Leicester.
So which page?
This is 1247, Lord.
Thank you. Yeah.
And Lord says there, if the defendant is proved to have prevented the true owner from exercising his rights, it's quite clear that there is a cause of action. Further down that page, at the bottom, there is a citation from the Howard Perry case, to which Ms. Blues referred. A denial of possession to the plaintiffs does not cease to be a denial by being accompanied by a statement that the plaintiffs are entitled to the possession that's being denied to them. And then paragraph 41 over the page, there is an observation that the Van Gogh case was unusual on its facts, and the observation made there is that access was temporarily detained. If I could ask the court briefly to turn up the Howard Perry case, which is in Authorities Bundle tab 7, page 232. And as a sideline passage, the court perhaps just double sidelines between B and D. And the court there, this is Sir Ross McGarry, Vice-Chancellor, looks at the situation and concludes that this is a clear case of conversion. And he refers there in particular to most of the rights of ownership, to an uncertain detention period. And those are the factors that play into his analysis that the tort of conversion is made out there. Applying that to the facts, as for Ms. Plu's submissions in relation to the work that needed to be done, and how there was no obstacle being put in place by the Secretary of State to that work being carried out. That is, in my submission, something akin to if the owners of the railway yard in Howard Perry had said, well, of course, you're welcome to come into the yard and work on your malleable steel here. It's a practical impossibility, and that hasn't been addressed in the 12 months and counting since the most recent decision taken by the Secretary of State.
I thought the yacht was still crewed by your client's crew.
Lord, it is, but it's crewed by my client's crew alongside at Canary Wharf, where there is no realistic prospect of undertaking the sort of marine engineering work that is required.
Right.
As to proportionality, my Lord, my learned friend Lord Anderson made the observation that when one is considering a margin question and the expertise of the executive, that is nothing to do with whether the material that might be relied upon is especially sensitive in some way. Of course, that must be right, because this court is quite able, through the use of a closed material procedure, to look at precisely the same material. What the expertise point is about the ability of the court, as compared to the executive, to set that sort of material in context and to draw the right sort of judgments from it based on its wider knowledge and understanding. And as to that, if I could just give the court the reference to the supplementary bundle, page 297, and at page 6, forgive me, paragraph 6 on that page, and paragraph 7, the following page, which we went to yesterday, the court will have, I think, already marked up the extent of the contribution that is anticipated. On the question of connection, if I could very briefly address that, driver 2, paragraph 11, that is behind tab 6 in the supplemental bundle. And you see that what is being relied upon for these subsequent observations in the paragraphs which Mr. Pobjoy directed the court is paragraphs 117 to 119 of the first witness statement. That is back behind tab 3 at page 71 and 72. And if the court notes that what's really being relied upon here is paragraph 118, and this is such matters as the sale to a Russian state-owned bank in 2012, 2 years before the invasion of Crimea, and the construction of buildings, some of which are now under the corporate control of a state business or a university building or something of that sort. That's the extent of the connection that is being relied upon with the regime. I was going to have a go at Mr. Birdling's essay question, but I think in view of the time, it may be best if I don't.
Well, we don't want to prevent you from having a go at that, since we're unlikely to produce our judgments in over the weekend. So if you want to put in a one-page note with your answer over the weekend, you're very welcome to do so.
Well, that's very generous, and may I thank the court and say that I will take that opportunity.
Now, Miss Plews, there are 2 cases referred to in reply, which you're theoretically entitled to reply to.
I haven't got anything further.
No? You're happy with Trocadero and Howard Perry being referred to?
Yes.
All right. Well, subject to any questions, I see none. It only remains to thank everybody for what has proved a very obviously important and also interesting hearing. It won't surprise anybody to know that we are going to take time to consider our judgments, and when you get them, this case above all, please bear in mind the embargo. The judgments are not to be used for any purpose of any kind except agreeing an order and the disposal of the case and costs. We will decide whether to give you notice of our judgments. It could be that this is a case where you just won't get them and you'll have to give us corrections afterwards, but we'll have a think about that, and any comments anybody wants to make can be made to my clerk. But other than that, as I say, I'd like to thank all counsel. I'm pleased that we've heard from so many of you, and I'd like to thank the solicitors as well, because the case has been very well prepared, with just one exception, which is the non-coincidence of electronic numbers in the core and supplementary bundle with Mr. Shvidler, but I'm sure nobody will mind that bit of pedantry.